From the Library of Congress in Washington, D.C.
Good morning. My name is Karen Claggett, and I am the Associate Registrar of Copyrights and Director of Policy and International Affairs for the United States Copyright Office. Thank you all for coming today to our Orphan Works and Mass Digitization Roundtables. Today, we plan to discuss in some detail issues relating to the problems and possible solutions to orphan works and mass digitization under copyright law. As many of you know, the United States Copyright Office has been intimately involved in these issues for many years. We issued a comprehensive report on orphan works in 2006 after extensive dialogue and analysis. Many of the recommendations in our 2006 report were reflected in subsequent legislation in 2008. Yet, unfortunately, at that time, the United States was unable to pass orphan works legislation. Nevertheless, the issue continued to receive significant attention worldwide. Several countries considered or passed orphan works laws, and case law developments, including a potential settlement in a major case, almost achieved by way of voluntary initiative what we were unable to do through legislation, that is, establish a collective management regime that would govern certain uses. We appreciate everyone coming today to continue this important dialogue. While we recognize from the comments already submitted that some of your perspectives may have shifted since our last review, many of you continue to acknowledge the real-world practical difficulties caused by orphan works and wish to work on a solution that appropriately balances a variety of interests and perspectives. Our goal today is not to come up with a consensus on one solution that everyone will be willing to agree to today. The issue is just too complex for that, and there are no easy answers or legislation would have been enacted years ago. In fact, different perspectives and opinions as to approaches and even the need for legislation can also be seen as a reason to have further dialogue rather than to cut it off. So today, we hope to take stock of where we are and get a general idea on those proposals that are worthy of more in-depth exploration by our office. We expect and welcome different opinions, but we also recognize there are a lot of voices that should be part of this discussion. And we recognize that just because one solution may work for one party or group does not mean that it is a solution that will work for the broadest interests as comprehensive legislation should try to do. Also, a brief word about the issues that we really do not plan to explore in detail today. I know some of your comments raise broader concerns about the copyright system as a whole, such as the length of copyright term, formalities, moral rights, the level of statutory damages allowed under the law. Although, as we recognize in our NOI, some of those issues are an appropriate part of the broader context of orphan works, we obviously cannot adequately explore those very broad questions in our current focus on orphan works, or certainly in the time allotted today. So we ask that you focus your comments on our specific questions and issues raised in our NOI and save broader comments, if necessary, for some of the further written comments that we are going to request. We obviously cannot turn today's discussion into a debate about how long the copyright term should be. All right, the first roundtable will cover the need for legislation in light of recent and technological developments. We will explore the current legal landscape and how any legal or other developments should change or shape consideration of orphan works legislation. As I noted previously, we expect there to be a variety of opinions. Some library communities, for example, may believe that at least for them, fair use already provides an appropriate solution for the uses that they would like to make. On the other end of the spectrum, some groups like the Writers Union have viewed legislation with skepticism for the very opposite reason, that legislation would grant greater freedoms than the law should allow. Perhaps there's a middle ground we'll be able to find today, something along the lines of what the publishers have proposed in terms of legislation, but we will see if that's something that we will be able to conclude. So I will start first with our introductions by our Copyright Office colleagues, and then I'll just go around the table starting here with just brief introductions of your name and title for from the participants. Jacqueline.
Jacqueline Charlesworth, General Counsel at the Copyright Office.
I'm Katie Rowland, Senior Counsel for Policy and International Affairs.
Frank Muller, Attorney Advisor for Policy and International Affairs. and Hoffman, First Vice President, National Writers Union.
I'm Jim Mahoney, the Vice President from the American Association of Independent Music.
Jamie Love, Knowledge Ecology International.
Matt Shears, Computer and Communications Industry Association.
Janice Pilch, Copyright and Licensing Librarian, Rutgers University Libraries.
June Bessick, Executive Director of the Kernigan Center for Law, Media, and the Arts at Columbia Law School.
Jonathan Ban, representing the Library Copyright Alliance.
And Brad Holland, the American Society of Illustrators Partnership.
Start down there.
Salley, Shannon, ASJA, the American Society of Journalists and Authors.
Jay Rosenthal, Senior Vice President and General Counsel, National Music Publishers Association.
Thank you. Emily Feltren, Director of Government Relations for the American Association of Law Libraries.
Courtney, Copyright Advisor, Harvard University.
Dave Hansen, Digital Library Fellow, Berkeley Digital Library Copyright Project.
James Hare, President, Wikimedia District of Columbia.
Allan, Adler, General Counsel, Association of American Publishers.
Great. So I will start, as I said, we're going to first start off with kind of questions that we've listed in our NOI, and then as the conversation gets further developed, we might ask follow-up questions based on some of the comments that we hear today. But I'll start very broadly, and anyone who wants to jump in, please just raise your hand. Have the recent legal developments, such as various fair use cases, obviated the need for legislation in the orphan works area or mass digitization area? Anybody who wants to open up? Jonathan?
So someone has to go first. So our view is certainly for the library community that the answer is yes, that the fair use jurisprudence as it has evolved over the past 5 to 10 years, certainly since the last round, has really diminished the need for orphan works legislation. We've always seen the problem largely as a gatekeeper problem, that the kinds of uses we wanted to make have always been fair use, but it was simply a matter of convincing our gatekeepers that it was fair use. But now with these recent cases, it's a lot easier to do that. And it's not just the fair use cases, it's the combination of the fair use case plus the eBay decision in the Supreme Court concerning the standards for injunctive relief as now it is being applied. That was, of course, a patent case. Now it's being applied in the copyright context. And so that reduces the problem of injunctive relief. And so from that perspective, we think that the status quo is a pretty good place.
And I actually have a question for Janice, just because I know that she represents a library as well, and I wanted to see if, explore that a little bit further to see if that position really has any regard with respect to the type of library that might be involved. So, for example, smaller libraries that, for example, don't have the protection of sovereign immunity, do they still see a need for legislation in this area as well, because they face maybe greater risk than some of the larger institutions?
It is true that some libraries face a greater risk. Some do not have the benefit of claiming sovereign immunity. Ours is one. And our view is that there is a need for legislation or a licensing solution to address orphan works and mass digitization. Recent legal developments have addressed digitization of published books, including display of excerpts, preservation, text search, and accessibility for the visually impaired, but there has been no ruling on the full text display of the digitized published books or on their further use, including use of orphan works among them. Furthermore, aside from the books already digitized, but not yet displaying in full text, libraries and archives seek to mass digitize to make other types of works available. Published journals and other serial publications, ephemeral materials, pamphlets, brochures, unpublished literary works in archives and special collections, manuscripts, diaries, letters, other writings, published and unpublished materials in other formats, images, audio tapes, and audiovisual works. Library mass digitization aims toward full use and reuse, and so we think that many questions remain.
Anyone else? David, and then...
Dave Hansen. So kind of echoing what Jonathan said, over the last year, the Berkeley Project has been involved with a an effort to develop some best practices and fair use for libraries and archives that want to make available orphan works. And over the course of the last year, we've gone around and worked with and had conversations with over 150 different libraries and archives of all different varieties, large academic libraries, small local public libraries, small historical societies. And the general sense that we've got from from every group that we met with is that there's increasing comfort with relying on fair use as a means of making orphan works available. And in general, that tracks the same rationale. We've heard the same rationale from all of those groups that Jonathan just talked about. There's a strong sense that those uses that libraries and archives are making are transformative, and then for orphan works in particular within the collections, there's a strong argument that there's very little market harm.
Okay, and I'm going to have a follow-up, but I'll say what the follow-up will be. In terms of, I know I saw in some comments a response about some of the best practices that have been developed. I know the library community has relied on those. Some content owners have expressed concern about those best practices because they haven't involved the perspectives of the people most likely to sue. So I did want to get a response maybe from some of the content owners on that side, as well as whether there's a belief generally that all of the types of uses that people would want to do would be covered under fair use, including both non-commercial and commercial uses. I think it was Kyle and then Allan.
At Harvard, we have 73 libraries currently, so we're a big target for a lot of orphan works. We share the same things that a lot of libraries share. Our concern with legislation is that it would dictate or circumscribe transformative uses of orphan works or fair use in a way that we can curb that, and that's kind of our concern. The DMCA was passed and it didn't say fair use in it. We had to have a test case for that. We'd like to avoid that if possible. Additionally, I think libraries would be more comfortable making digitization assessments if the level of risk were diminished. So we could do that through 504(c)(2) to indicate that courts have discretion to reduce or remit damages, statutory damages. And I know we're getting off a little bit though, but that's the kind of legislation we might be more comfortable with. And at the 73 libraries that we have at Harvard, in the last year or two, echoing Jonathan again, there's been more comfort level with the decisions, HathiTrust, Google Books, et cetera, of making these kind of transformative uses.
Allan?
Well, undoubtedly any use of a copyrighted work at some point can rely on an argument of fair use. As we understand the problem of orphan works, we think it's important that there be solutions that are nationally consistent and uniform. And the problem with relying upon fair use is that it is not a foundation upon which orphan works can really stand. In any event, even if you use a fair use approach, you would need to have some notion of reasonably diligent search if the concept of orphan works is actually being maintained, and we're not simply talking about an assertion of fair use as it would apply to any other use of a copyrighted work, whether the copyright owner is known and available or not. I think it's ironic that the principle of legislation defining reasonably diligent search and balancing that against limitation on remedies has been picked up in the European Union in a directive that emphasizes the importance of a common approach and harmonization. If you can understand why the internal market in the EU would want a common approach and harmonization, you could certainly understand why in the United States we don't want rules for orphan works or determinations for uses of orphan works to differ from federal district to federal district or circuit to circuit and state to state. And for that reason, we think that legislation is basically necessary. We would also point out that in addition to the question of legal certainty, which I'm glad to hear the libraries are feeling more comfortable about, but many individual users may not, and we are talking about more than just library use here, there's also the question of whether or not certain types of uses that can be permitted under an orphan works legislation simply wouldn't be permitted under fair use.
Yes. I'm Salley, Shannon. First, I want to say thank you for including the people who actually create the works here. Our voices are not often heard in these discussions. Our concern is we're rather between the devil and the deep blue sea here with orphan works. We would be content to rely on current law, but we see this coming. The recent technological changes have created many difficulties for us, centered around the fact that publishers so often disappear. We see the problem so much not being an orphan works problem when books and printed matter are concerned, but an orphan publisher's problem. Our concerns are twofold. One, we believe that an orphan work should belong to we the people, and it should not be controlled by any corporate entity. We know that the Copyright Office, and many of us, has concerns about having adequate money for the Copyright Office to supervise a registry or any kind of adjudication of these works. But we're very concerned that the decisions about these works will essentially become something that is made by corporate entities without the supervision of independent parties or under the regulations that would be derived by the Administrative Procedures Act, and we're very concerned about that. We also stand in the place that book contracts did not have digital rights provisions until 7 or 8 years ago. And so often when people try to search and find the creator of a printed work, they go to the publisher, but the publisher may be out of business or may not know that the rights are divided. So our concerns really center around two things: proper supervision and not turning this over to profit-making entities, and two, the nature of diligent search, which I'm sure we'll address much later.
Yes. Yes, Emily.
I do agree with many of the comments that have been previously raised by some of the libraries about reliance on fair use. I think that's true, but I do know that some law libraries do continue to be risk-averse. So for that reason, we did take the position that legislation would be needed, of course with the caveat that Congress is a difficult place right now, as we all know, and it would potentially be dangerous to open something like this up to legislation. However, we still continue to support the idea of legislation. We think that reliance on the court decisions on fair use, while certainly has been positive for the library community right now, there is always the possibility that the courts could go the other way as well.
James, and then June, and then Ann.
Thank you. James Hare, by the way. So Wikipedia is very observant of copyright, and we wish to follow copyright laws to the greatest extent possible, and we believe that legislation would be useful in letting volunteers better comply with the wishes of copyright holders if they can be located, and a law would allow for a diligent search standard that would make volunteers more comfortable using copyrighted works.
Thank you, June. And I did want to follow up. As I said, I kind of have two kind of outstanding questions. Just do fair use decisions apply, or would they apply to all the types of uses that people would want to make for orphan works? And are there differences either within the library community or outside of the library community in terms of whether fair use is certain enough to be able to provide the basis to be able to go forward with the type of uses that people want to make? June.
Okay, I don't think that existing law really provides sufficient guidance for users, because there is a wide variety of users, not only nonprofit libraries, but also nonprofit libraries that are linked with a for-profit organization, and they're very concerned about the relationship between the two. And then there's individual users, small libraries, and so on. I also don't think it provides sufficient protection for users, and that's this question of what is an orphan work. There's a lot of assumption that the owner of an orphan work is somebody who hasn't been conscientious, who hasn't followed up on their rights. But there are works that become orphaned even now, and sometimes it's because of not carelessness, but some kind of wrongdoing or carelessness on the part of the user rather than the right holder. So I think that one of the reasons we need new legislation is we need to decide for example, what should the search standard be, specifically with respect to orphan works? And with respect to orphan works and mass digitization, who should be allowed to make these unconsented uses and under what terms? What should be the safeguards? And then with orphan works, I think there should be a means by which right holders can somehow reclaim rights if in fact their work has been wrongly deemed to be an orphan work.
I was happy to hear my neighbor to the right's comments here because while many of us who represent creators believe that fair use may have gone too far in the last couple of years, we would certainly be content with what they've already done. In 2006, we testified before the Senate that we believed the orphan works problem could be solved with specifically crafted expansions of fair use, as long as they were carefully tailored to the necessary uses. What we saw in 2006 and 2008 was the excuse of orphan works used to go far past orphan works uses into commercializing the uses of artists who were working and trying to manage their copyrights, and with the recommendation that all of this be handed over to commercial entities, which would compel artists of every kind, writers, cartoonists, illustrators, fine artists, to register everything they've ever done with commercial entities, to be created in the private sector. And I want to echo what Salley said a minute ago. Creators have rarely been heard in this. In 2008, the Small Business Administration conducted a roundtable in New York City at the Salmagundi Club, and it was the first time, to my knowledge, that any branch of the United States government has actually inquired into how the orphan works proposals in 2006 and 2008 would actually affect the small business owners who were creating the work. And we submitted, this panel was held at the Salmagundi Club. Many people came as far as from across the country to spend a few minutes saying their few words about the subject. But the rest of them submitted papers, which we submitted to the Small Business Administration. This is not a collection of work by feckless artists who don't know anything about their business. This represents illustrators, represents cartoonists, photographers, musicians, writers, and it even includes amendments that we proposed to the 2008 law that would have limited orphan works usage to the specific cases involved. And to the best of my knowledge, none of these people, despite the fact that the SBA provided a roadmap of the issues that concern creators and people who can speak out from the various disciplines about this, to the best of my knowledge, not one of these people has been invited to testify before Congress. And I think that would be an oversight, that Congress ought to be looking into this and invite some of these people to testify so that they get a broader perspective of how this affects the creative community, not just libraries and museums. And our real concern is the extent to which libraries and museums are used as the stalking horse for the commercial entities that simply want to compel us to give them our work so that they can use it to compete against us.
Anybody else? Yes, Jay, and then Ann.
Just a few points. First of all, on the certainty of fair use, the recent case that I think everybody is kind of focusing on, it's in its first round. I really wouldn't, take a look at the Google case.
And not to interrupt you, I was going to ask, my second question would be, would opinions change if either Hathi Trust, Georgia State, or Google Books were reversed on appeal?
Yeah, well, knock on wood. Reverse on appeal. Yes, I think that this again brings the, you're asking, should we have a law here? Should we at least be looking at it? Our viewpoint has always been that music should be out of orphan works for all sorts of reasons, because we can really, most people can find the owners of works. But as the Google case in particular, I think this is the first round. I mean, the second, the Southern District is not the Supreme Court. And I think that this is really the idea that we are changing fundamentally the contours of fair use, and a new public interest test is being introduced, has really activated a lot of folks to look at, maybe we have gone too far in a fair use context in the courts. So I think there's going to be a lot to go there. The second point is that, while we have always taken the position that music should be out, we also, from the last time we had all of these hearings and roundtables, there have been technological advances in the free market. In particular, in music, you see a lot of activity around the idea that we must understand we have to find folks, we've got to pay them, and there has been a lot of work for that, meaning that it's easier to find the owners of these works than ever before, and I think that's just going to get better as we move forward. And I think that's all happening in the free market, as opposed to in any context of a government-run, registry of some kind down the road. We are not against the idea of going forward with an orphan works legislation, but it's got to be in context of all of that. That fair use is not the place to go. We need more protections for copyright owners, and also we have to look at what's going on in the free market in terms of being able to find these folks and to get them to approve the uses.
Yeah.
As you said, the National Writers Union believes that there is no need for orphan works legislation. There's no evidence that people seeking to use published works in a legitimate way for a legitimate reason are conducting any kind of search and are unable to find the authors of the works. That's the only way to ascertain who holds the right to the work and whether and how the creator is commercially exploiting the work. Both U.S. law of fair use and the Berne Convention require consideration of what is normal exploitation of a work. Technological developments over the last decade have multiplied the means by which an author or other creator may commercially exploit his or her work. E-books, web pages, databases, and other ways to remix the work and make it a different work. It's routine today for an edition of a book, for example, to be out of print, but for some or all of the content of that book to be being exploited in some other format by the original creator. Libraries are risk averse, but the only thing that protects the rights of a creator are risk aversion. If we cannot seek damages for unpermitted use of our work, copyright is meaningless to us.
And I have one quick follow-up question to you, specifically before I open it up. Would your opinion change, for example, if courts felt that they had to rely on fair use and expand, perhaps in some people's view, fair use to accommodate uses that they feel are socially beneficial because there is no alternative exception?
It's possible.
I just want to address the question of whether fair use is the appropriate vehicle for this. I've said that fair use is incredibly expanded over the past several years, and I think it's expanded to the point that it is distorting the law. It's sort of taken over some of the other exceptions like Section 108, Section 121. Now, I'm well aware in Section 108F, there is a statement about the relationship between Section 108 and fair use. However, I think we've gone beyond that. I think essentially fair use has made some provisions simply meaningless. They've written them out of the statute. As the cases currently stand, now as was pointed out, those cases could change on appeal. And I just want to add that the societal benefit isn't a new consideration, but it's been given new weight. There are many things in this world that provide a societal benefit, but that doesn't give them a free pass, and I think that's true with fair use as well. The question isn't whether some of these things like the mass digitization databases have a societal benefit. The question is how you get there, what the appropriate avenue is. I don't think in any area of the law, and that's true with copyright as well, that we think that the end always justifies the means.
And then Jonathan?
On the question of fair use also, recent legal developments have been positive for libraries with respect to book digitization, but in the landscape of mass digitization, we believe that fair use too easily becomes an opt-out system that offers little recourse outside of costly and time-consuming legal action. Because, as is well known, the takedown system is really ineffective. Fair use does and will unfairly affect many right holders. Most ordinary people don't have the means, the knowledge, the time, or the resources to litigate over use of their works. Keeping in mind that we're embarking on mass digitization of many different types of works, if only the wealthiest and the most determined right holders are able to enforce their rights and their livelihoods, we will have disenfranchised many highly creative and talented individuals in our society. And that's just not fair. Judge Chin said of the Google Books project that all society benefits. But all society doesn't benefit if asserting rights requires an expensive lawsuit. Copyright becomes a system for the 1%. Final comment, which is, best practices can work very nicely, and sometimes they do. But when they're used as a way of doing it anyway until you get caught, and the only people who can catch you are wealthy right holders, the system has broken down.
Jonathan?
Well, I guess a couple of things. First of all, I think to the extent that the system is broken down, we all know that the root cause is something that we're not really supposed to be talking about here, but it's the very, very lengthy copy term, the absence of formalities, and as a result, that so many things are covered by copyright where there was really no intention, and there's no economic sense, there's no reason for things, especially we're talking about ephemera and all the kinds of photographs and the things that are, so many of the things that are in our archives, it really makes no sense for them to be subject to copyright in the first place. But we're not supposed to talk about that, so we won't.
Please put it into your comments. We do. We just don't want to have a huge debate, because I think that could be a long conversation.
It is the elephant in the room, but that's fine. Turning to the specific question you were asking about fair use, well, I don't think it's simply one or two cases. I mean, it's a trend of cases, and I think June would agree. It's not just one or two cases. It's many cases in many circuits. Our view, and we think it's June might think it's a negative development, we think it's a positive development. Certainly if the trend changes at some point, then we might have a different position. But right now, the trend is in our favor. That's not to say that, again, in a perfect world, one couldn't sit down and come up with a legislative solution. Again, in a perfect world, there are lots of legislative solutions to lots of problems, but the point is we don't live in a perfect world. We live in this world, and in this world, the likelihood of coming up with a legislative solution that really is better than, and I'm saying better than from the perspective of the user community, is very unlikely. The nature of the reasonably diligent search, how prescriptive it would be, and how likely it would really be to cover all the different nature, the different situations. Again, every work is different. Every search is going to have to be different depending on what you find. What you do at step one depends on what you find what you do at step two is determined by what you find at step one. And as a result, it's so complex. The likelihood of legislation really, as a practical matter, besides even if we could ever get there, but the likelihood that legislation could really provide anyone any more certainty about whether they did a reasonably diligent search or whatever the other framework was, I think it's illusory. It really will not provide anyone with any more certainty. It'll just be more loopholes or more hurdles that everyone's going to have to jump through.
And here, but I just had a quick follow-up question for you, Jonathan. In your view, just as following up on an earlier question I had, would fair use cover all of the uses that you think at least the libraries within your organization would like to make of orphan works, and have, to your knowledge, any cases directly address all of the types of uses that the libraries would like to make with orphan works?
Well, I would say that chances are that would fair use address all cases? Probably not. But I think it's highly unlikely that legislation would address all cases either. But I think certainly going back to Dave's point, the combination of, that the uses that we're trying to make we would see as transformative, and also that we would assess, in our view, that there would be no market impact. I mean, those two factors together would suggest that in the vast majority of cases, the vast majority of uses we want to make, that they would meet the criteria of fair use. But I'm sure that there would be situations where they might not, but then I don't think that those would necessarily fall within any other kind of legislative
I'm going to go to Brad, Sally, Jay, and then Kyle.
I just wanted to respond to Jonathan's comments about certainty and uncertainty. We heard this in the first roundtables in 2005, where Christopher Sprigman, for example, insisted that infringers needed certainty that if they infringed a work, they couldn't be pounced upon and penalized for the maximum penalty. As a matter of fact, it's the uncertainty that is the only protection that creators have for copyright. Most infringers know that most work is not registered. Most of them know that if they infringe the work, they may never be found out because you can be infringed any place in the world at any time by anybody, and unless you happen to be there on that spot at that time, or unless somebody you know identifies your work and tells you about it, you don't know you've been infringed. If you do find out that you've been infringed, you may not be able to track down the infringer, and while the infringer may have to do a reasonably diligent search to find you, if you've been infringed, you have to do an absolutely successful search to find the infringer, and then you have to make him respond. If all of that happens and you drag the guy into court, it may still come down to a matter of who has the most amount of money to stay in court. So the infringer can bet that if he infringes a work, he probably won't get caught, the work probably hasn't been registered, and he probably won't be sued. But he can't be sure. And that uncertainty is the only protection that creators have for their work. There's no Copyright Office police force. There's no Copyright Bureau of Investigation to go out there and enforce our copyrights. We have to enforce our own copyrights, and the only mechanism that the law has ever given us is the penalties for infringement and the uncertainty in the mind of the infringer that he just might get caught.
Yeah, I will say that just to respond to that, it seems like the libraries are saying there is no more risk of, or uncertainty, at least with respect to the uses that they want. So that kind of cuts both ways, I think, somewhat. Going to Sally as well.
I just want to say I love the idea of a Copyright Office police officer. Can we write that into the legislation and hope to get it through? I'm heartened by some of the things.
Can't you see little armbands with copyright Cs on them?
I love it. I love it. I'm particularly taken by what Jay said about perhaps the pendulum has swung too far on fair use. Of course, that's our belief. There is considerable market harm being done to writers, and there hasn't been adequate attention paid to that. And I'm also greatly heartened by what Janice and June said, that the end doesn't always justify the means. So it's gratifying to hear that concern. For us, full text display would be a prospective nightmare for the reasons that Brad delineates. We are alone out there trying to protect our own works, and it's very difficult for an individual creator to go up against a corporate entity, and the larger the entity, the more difficult it is. I just want to emphasize that.
Okay, Jay, then Kyle, Jamie, and Allan.
Okay, just a couple points. First of all, just to respond to the issue about copyright owners as in the 1%, songwriters are certainly not in the 1%. In fact, in the digital age, songwriters have become impoverished, and all you have to do is go to Nashville and talk to the songwriters down there and understand how much they've been hurt over the past 20 years. Same with photographers, same with a lot of other classes of authors. So in balancing these interests, I think we also have to keep in mind that we're talking about a lot of authors who are really not doing well at all out there. Second of all, the issue about whether fair use kind of is better than guidance that could be found through an Orphan Works regime, I think guidance is probably better. And I think we've always taken the position that if we're going to go down this Orphan Works road, we would much rather create best practices, and I know we're probably going to talk about this more in the reasonably diligent search panel, but we are much more interested in creating best practices that would allow folks to be educated on how to find these works than to rely on some amorphous fair use concept that might land them in court later on.
Kyle? And then
Thank you. A couple of responses to a couple of things that have been swung around this panel. I feel like I'm in a time machine and we've been having this conversation in 2005, 2008. We're having it again. What are the chances that legislation will be passed that satisfies everyone at the table? 0. What are the chances that legislation will be passed? I mean, that's up to Congress. But what we have now is we have best practices now, and David's going to talk about this. We have the fair use now. It's not good enough, but it's not perfect, but it's good enough. And I think that we avoid this kind of vicious cycle that we've been going through over the last 7 or 8 years with regards to orphan works. I mean, let's rely on what we have now. Codes of best practices are useful as a tool for education, risk mitigation, indicators of what's reasonable, make aspirational goals for a particular profession, job function. Librarians are information professionals. We're the ones that are probably going to end up doing the searches and helping the users. That's what we do. This is cost and time consuming. Janice mentioned litigation is time-consuming and costs money. Absolutely, but so does searching for a book that's an orphan work or a photograph or trying to find it out. There was some study that we did at Harvard where someone spent 400 hours on 5 or 6 books to really try and find who owns this. And that costs money and time, too. And as for the remedies that are offered to folks, you know, the only remedies that a creator has is bringing something to court in the Small Business Association report. If they wanted to bring it to court, they would have to register it, right? That's the prerequisite for a federal district court complaint, that you would have to register the work, so it no longer would be an orphan work. So I'm thinking that there's a lot of things to do here with infringement, with registration, and time. You know, if it's a true orphan work, you can't find that person, and that person may not want to be found, and that affects the 4th factor. Because we're talking about if they want to take advantage of the market that they've had for creating these works, they may or may not have registered this stuff. And again, that's also the elephant in the room. So I apologize for bringing up the elephant again.
I'm going to go to Jamie, then Allan, then James, then David, and then Jim. Jamie.
Thank you. First, I mean, I agree with a lot of things that people here have said. I think the book publishers have said that they thought that the Sean Bradley legislation was a good basis for a legislative solution. We like that. We tend to agree with that. I think that a lot of people here are anxious because they think that Congress will just screw things up, so they're a little risk averse about that. That's reasonable. What people would like to have is something that expands access to orphan works for us. Fair use is, it's gone a good way from our point of view, but I think that I think that there are a lot of uses that it will not go to. I think that there's a lot of things, particularly that commercial publishers would do, that we would find beneficial from our point of view in terms of including works. I would say that for myself, I hear all these people talking about creators, and I don't know, I spent the weekend working on a paper where having access to older primary source material, which I could find on the internet, was really important for me. It's some paper I'm being paid to do on innovation inducement prizes, and I'm trying to sort of profile an old case that happened in the 19th century and things that happened in the last century. And these mass digitalization projects have really opened up a whole area of research for people of just things that they didn't even really, gaps in their knowledge and things like that. People will pay me to do that kind of work if I have access to data, if I have access to sort of the primary materials, and it makes my contributions more available. So I don't know whether you consider that part of the creative process, but it's certainly part of our situation. Now, if you look at the 96, the previous legislation, a lot of it was based on limitations on damages and on injunctions. If you look at the trade agreements, like the TPP, the trade agreements have these requirements which are completely unnecessary and overbroad in the published leak, Article QQH4 on civil procedures, that require the judicial authorities have to have the authority to consider any legitimate measure of value the right owner submits, including such things as suggested retail price. If you have in trade agreements things that obligate you to do things which are contrary to the legislation, you're just creating a problem, particularly when that's subject to investor-state dispute resolution, where private parties, including the people around this table, can actually sue and get damages against the U.S. government for violating the terms of the trade agreements it's entering into. Also, these trade agreements have, and this one in particular, the U.S. proposals are really aggressive on the term. Now, if you wanted to sort of...
Jamie, I'm going to have to just interrupt and ask you to kind of wrap it up a little bit, but and also just to give another caution. Obviously, I know that there's separate issues with respect to trade agreements and the TPP, which there's no official text out there right now. So that's kind of one of the areas where we're not going to be able to explore in a lot of detail today. But
well, you're trying to fix a problem, and you're doing something as we speak in a process that your office is actually part of the consultative thing, which has a huge impact on the potential contours of solutions you can do. So that's why I brought it up.
Yeah,
now, in terms of the flexibility you have on legislation, on things like introducing things, formalities type obligations, one of the areas of flexibility you have is in areas that are in excess of the TRIPS term. The WTO agreement is the most important for a term because it's subject to dispute resolution, and it's really impossible for the United States to modify that agreement. The TRIPS term for photographs is very short, and for published works, other works, is 50 years from the end of the calendar year of authorized publication. It's not even 50 years after life. So it is possible within 50 years after something's been publishing to introduce formalities type thing and not be subject to TRIPS type sanctions, and even shorter for other things. Now, the final comment I wanted to make is that I understand that in certain kinds of art, in certain kinds of that music has a different situation, that photographs have a different situation. I think text, all these things are kind of different. And one of the challenges of the legislation is to have kind of an overarching framework that fits all these very special cases that everyone has. Now, if I look at the rulemaking that takes place in the DMCA has people make proposals for exceptions effectively to the rights of copyright owners. They have to be empirically based proposals. They tend to be narrowly crafted. There's kind of a debate. It's kind of done by the Copyright Office instead of the Congress, and they're modified from time to time. The big complaint we have about the DMCA rulemaking process is the automatic sunset, which we think is a mistake. But if you take the automatic sunset out of the process, that might be the right way to think about a legislative way forward on the orphan works, so that you don't have to put photographers, illustrated work, music, text, everything into the same basket, things that were published commercially first versus things like Jonathan mentioned that nobody really intended to be commercial products in the first place, all into the same basket. You can kind of like, and if Congress could give you the authority to adopt rules and exceptions and special treatments for orphan works, and then you could sort it out through these rulemaking process and then iterate it as technology changes. People mention that technology is going to make it easier for people to identify right owners in the future. I think for a lot of work that's exactly right, and I think that you do not want to necessarily use the orphan thing as a complete solution. And I think the mass digitalization issues, while important, are also need to be unbundled a bit from the orphan works problem, because I think one of the problems on the mass digitalization problems is an economic issue of who pays for the mass digitalization. Because I think one of the problems with the Google Works thing is we've sort of set right to private companies the cost of doing the mass digitalization, and that's led to sort of concerns about the monopolization of the output of that. Thank you.
Thanks, Jamie. And some of what you said with respect to regulations is something that certainly we've heard from some of the comments, as well as some of the foreign governments have considered having a high-level set of detail in the actual statute and more detailed regulations that would be more flexible in terms of addressing the conduct. I think Allan was the next.
I just want to make sure that this type of conversation doesn't mislead people by creating a false dichotomy about the need for legislation and the availability of fair use. They're not mutually exclusive. The simple fact of the matter is, as I said at the beginning, fair use is there, and fair use is always there for somebody to be able to assert that they can make use of a work without permission from the copyright owner. But, you know, in the 2008 legislation that Jamie mentioned, there was a savings clause with respect to fair use because it was understood that if a copyright owner were to come forward and claim the rights with respect to his work, that shouldn't prevent the user from asserting that the use was fair use in any event. But the difference here is, of course, that if people want to make use of fair use to use a work without having to worry about permission, they can do so now, but they won't get the benefit of any kind of limitation on remedies, and they're going to have to forego arguing the notion that market harm factor is to be assessed on the basis of the idea that, well, there's no copyright owner evidently available, and the work itself doesn't appear to be currently being marketed because it's out of print. In those events, you're going to have to get into the issue of whether or not there was any actual inquiry for a copyright owner. And once you do that, you're already down the path to having to decide what would constitute a reasonable inquiry. And we've already gone so far in defining the notion of a reasonably diligent search. It really would be sort of pointless not to use that for those people who are interested in getting some assurance that they could limit remedies if they're wrong, or if their search turns out, unfortunately, to produce the wrong results.
And do you have any response to some of the comments that, you know, in addition to the case law, things like best practices on fair use have come up and have provided greater certainty?
I worry about best practices. Best practices provide greater certainty only to the people who create the best practices and who actually favor the way they work. Most of the best practices we hear about from the library community haven't involved any discussion with copyright owner stakeholders. So obviously there's some difference of opinion about those. But I think more importantly, we have a real example in the case a few years ago of the Orphan Works project at the University of Michigan. Those were people who we believe, with all good intentions, set about creating a subjective set of criteria for how you would determine the orphan status of a work. And they proved to be dramatically wrong on a number of the conclusions that they made. And part of the reason for that was because they had not gone through the effort to try to develop, as a legislative process would, and indeed did do in 2008, all of the various kinds of sources that it would make sense to say should be checked as part of a reasonably diligent search. And if one can only imagine, if this was the case with the University of Michigan and its Orphan Works project, imagine if every university in this country decided for itself that it was going to create its own subjective criteria for how to determine when a work was an orphan work and could be used without concern about permission. You'd have a patchwork quilt of a similar kind that you're going to get if you were to rely exclusively on fair use and let federal judges all across the country determine in individual cases ultimately when a work should be accorded orphan status for a particular use.
James, then David, then Matthew, then June, and then Sally.
Thank you. And I'm noticing.
Remind me if I forget who's going next.
And I'm noticing this thread between fair use versus legislation that could arguably limit, or rather limit the remedies that are available to current copyright holders because it would allow for safe harbor and provisions and so forth. But what I'm thinking is, I mean, legislation goes both ways. It could make broader use of copyright, it could expand the concept of fair use, or it could help curtail some of the fair use. So you could actually use legislation to say mass digitization requires a lot more diligence than it requires now. But I'm thinking the value of legislation would be to help make use of a body of works, over a century of works, that cannot be reasonably used now because the copyright status is uncertain. And as an example of this, there's a photograph of the poet Ezra Pound as a young boy. The picture is from 1898, but it was never published, so under US law it is still copyrighted. And a lot of effort has been expended into figuring out who is the copyright holder of this picture. And no one can figure this out. And you could argue that fair use provides for the educational use of such a photograph, but it is ultimately a defense, and legislation would allow for the use of this copyrighted but never really used for commercial purposes work to be made available for volunteers to use on not-for-profit educational projects.
David, then Matthew.
Sure. So two things have been floating around that I wanted to address. The first is this idea about risk aversion and that keeping libraries and archives and other users from actually exploiting orphan works. First, I think it's worth noting that there are no cases that I know of that where we have an instance where a user has actually used an orphan work, made it available, and then an owner has shown up. And I think that's notable because that speaks to this whole risk aversion issue of whether there is it's just a real or a perceived risk there. Now, we do have the Hare Trust case, but Allan, actually, I would argue that part of that process was listing the works and putting up online, publicly available, a list of the works that would be made available to ask people to identify them. So, from my perspective, the Hare Trust, the Michigan orphan work search process worked. The Authors Guild identified some of those. They didn't anticipate the suit, but in that respect, it worked. But the second thing is throughout this best practices project where we've gone around and talked to all sorts of different librarians and archivists, the thing about risk aversion that we hear more often than not is it's not just the copyright issues that are preventing them from using these works. There are all sorts of other issues embedded in there, especially with special collections where there are privacy issues, there are concerns about the integrity of the work and telling the story as accurately and truthfully as possible. And so to say that copyright is preventing libraries and archives from making orphan works available is really a simplistic way of looking at it. There are all sorts of other things embedded in there, and a legislative solution that is aimed at alleviating the copyright risk may not do nearly as much as one would think it would do because all of those other issues are embedded in there. The one other thing I wanted to say is kind of in defense of the best practices. Like orphan works, there are no cases that I know of where someone has relied on these sets of best practices that have been developed over the last few years and been successfully sued. And I think that speaks a little bit to their legitimacy and their usefulness for user groups. And for libraries and archives in particular, they're some of the, throughout this best practices project we've seen, they're some of the most conscientious copyright users that there are. And the creation of their best practices, which for orphan works is coming out soon in the next month or so. What we've seen go into that is sort of a high level of concern, not just about the perceived risk of getting caught, but the perceived harm that is done to a potential owner. And it's a lot more nuanced and interested in kind of the underlying preservation of the integrity of the copyright scheme than it is just whether we will get caught or not. And I think that's worth mentioning.
Okay, I'm going to go to Matthew, June, and Salley.
Matt Shear, CCI. So we're close to finished with our first panel here, and I had sort of assumed by this point someone would have raised the issues that I think are really important and we haven't talked about that much, is these definitional questions which have been acknowledged in some of the previous NOIs. Certainly one of them has been alluded to, which is the precise contours of what's an orphan work, and that ties into the reasonable diligent search and all that. There's also a very broad question mark around what exactly a mass digitization project is, and I think...
And we will have a panel devoted to that on the second day.
Right, so in that sense, I think we may have the sort of the cart before the horse, because there isn't a whole lot of certainty about what it is we're talking about here. And you know, at one level, mass digitization could describe, you know, a very narrow set of physical to digital translations, which have been the source of some of the litigation that's come up. You know, a poorly worded definition could sweep in a lot of standard database-related activities that go on in business all the time today, and I don't think we'd want to see that. That would clearly have a lot of unintended consequences, and I think that's something that needs additional exploration. And I just wanted to make a comment. I was really surprised with Jamie's suggestion about the notion of a DMCA-like process for dealing with orphan works, because you know, when the solutions that we're considering seem to reflect the sort of increasingly regulatory approach of copyright, that makes me very nervous. And yet I understand the appeal of it, because it seems like it seems like something that we're familiar with and that could work. But the complexity of copyright has great distributional consequences. It's a system that's much more easily navigated by sophisticated players than individuals. And I suspect that some of the aversion to a legislative solution is that there is no confidence that a solution would not also be itself very complex and regulatory. And if that's the case, then that solution will have similar distributional consequences and isn't going to help some of the stakeholders at the table, because they won't be able to navigate it.
And before we get to June and Salley, who I think I have as the last people, we do want to have the opportunity to open it up for the last few minutes to people from the audience to ask questions. So I'm going to throw out my last two questions to the panelists to respond to after June and Salley speak, and then we'll open it up to the and Jim, and open it up to the audience as well with any final thoughts. But my last kind of two general questions would be, one, as Allan mentioned, previous legislation did include a savings clause. There are savings clauses already in the Copyright Act for fair use, for example, in Section 108. Would having a savings clause explicitly to support and sustain fair use address some of the concerns, especially from the library community, in terms of being able to ensure that fair use is not in any way negatively impacted by a legislative solution? And then my second question is just to bring in the international element a little bit. As many of you know, definitely other countries are working on and or have adopted orphan works legislation. The fact that copyright is now global and other countries are addressing this, does this also impact at all whether the United States should do something now, since quite frankly, other countries are going to go forward with or without the United States on this issue as well? So those are the last two questions I'll open up to the panel, and then I'll go right now to June and Salley, and then anyone else from the panel to respond.
Well, with regard to your latter question, I think that this would be the time to go forward if we want to try to influence other countries as well. I don't think trying to export fair use is the way to do that, certainly. I just want to mention a few different things that have come up. One is, one of the reasons I favor legislation is I think that the Copyright Office should have a role in developing the guidelines rather than this being done sector by sector by users. I think many of those guidelines are aspirational, and while I agree that especially librarians are extremely conscientious people, not all the guidelines have been developed by librarians, and they've all, I think, been developed by people who sincerely believe they should be able to make certain uses, but still they don't have the involvement of anybody who's right holder. One point I wanted to make up to discuss, there was a point earlier about mass digitization designed to make available legacy works that otherwise would not be available. And one question I have, if we rely only on fair use and not on any legislation, is what happens going forward? What happens when the reasoning for putting something in your database isn't, well, no one can get access to it, but instead it's not part of my database, and my database has to be comprehensive. So I think there are some problems with that as well, and I don't think we're really talking about limiting it to legacy works in the future. And by legacy works, I mean works that were created in print form.
Salley?
Yes. I just want to say that, yes, I believe that librarians are diligent and conscientious to a very great degree. And I also want to say that it doesn't follow that just because a suit hasn't been, an orphan work suit hasn't been successfully pursued now, doesn't necessarily mean that our best practices and the questions we're asking are correct. When the Hattie Trust folks came forth with their list of orphan works, I was no further than halfway down the first page before I saw two working writers whom I personally knew, and it took me less than 10 minutes to find a phone number and address for one of them. Now, if I can do that in 10 minutes, and conscientious librarians have worked very hard to determine whether those are orphan works, something is wrong about the questions we're asking.
Thank you. And does anybody want to respond to the last two questions I had, for the savings clause and the international aspect? Brad, then Jonathan, and then Ann?
I just wanted to make a general comment, and it does affect the issue of legislation as a model for foreign legislation. Because there are so many lawyers involved in this, we're talking about this as if it's some arcane branch of the law. It's not. What you're talking about is prescribing business models for people in businesses in which, frankly, most of you don't know enough about to be creating business models. In 2008, we were lectured by a group that artists now learn that they have to change their business models. Well, listen, there isn't an artist or writer, photographer in this business who isn't already trying to change his business models, because the landscape in which we have to create has changed more dramatically than at any time since the invention of the printing press. Every single one of us is reinventing. I've been in this business since 1961. Now, for me, this is a huge learning curve to jump over. After more than 50 years of working in this business, I have to digitize 50 years worth of analog works. Paintings 5 feet by 7 now have to be digitized. Metadata has to be dug up from as far back as half a century. Can't be done. The marketplace will create business models. It can move faster than Congress. It can move faster than the Copyright Office. It can move faster than lobbyists and legal scholars. If an artist comes up with a better means of being discovered, other artists are going to find out about it and they will copy the same technique. Leave this to the marketplace. This is the best laboratory for creating the business models. Don't allow Congress, which has done no investigation whatsoever into the way we work, into the way writers work, into the way songwriters work, into the way photographers and small business owners work. There's been no study whatsoever of how we work, and they are not prepared, they're not qualified to write business models for us.
Thank you, and we certainly will take any comments that you want to submit during our process and make sure that they are analyzed and presented to Congress as well. Ann?
I just want to say that the National Writers Union is intervening in many of the overseas processes. I don't think they're doing any better job than we're doing in the U.S., but we want to try and get the voice of the creator heard everywhere.
Jonathan, then Jamie, then Jay.
So with respect to savings clauses, obviously if ultimately what Congress comes up with is sort of a complex regulatory structure similar to what was considered the last time around in 2008, then obviously a savings clause would help. But I have to note that even the existence of saving clauses in, let's say, Section 108, rights holders still assert that that savings clause doesn't mean what everyone thinks it means or what its plain language means. And even June before was saying that, if you interpret fair use too broadly, it swallows up the exception, and we don't think that that's right. But the point is that the mere existence of savings clauses by itself is not sufficient to eliminate concerns. Now, it could be what we propose in our comments is that if Congress does decide to do something very narrow, let's say sort of like a one-sentence amendment to 504c2 that simply gives a judge the discretion to consider orphan work status when assessing statutory damages, something really, really simple, then you might not even need a savings clause because you're simply talking about a simple adjustment to 504c2, and you don't need to get into, it's not really an exception for which you need the savings clause and so forth. So there are ways conceivably around that specific issue.
Jamie?
One of the things that we think that when people mention the foreign legislative efforts, one thing that we're concerned about in some of the proposals, like in Europe, is create the idea that every orphan works generates some kind of a monetary claim for a collection society. And we don't like the idea that you just have sort of automatic money being paid when you can't give it to, when it, the money doesn't go to the person who's the actual right owner. I mean, it would be one thing if you sort of escrowed the money and used it for some public purpose that benefited the users, like mass digitalization projects or buying up rights from right owners, or something like that. But I think just sort of like collecting money for works where you can't find the owners and giving it to somebody that didn't write the work or doesn't really have a legitimate claim is something that we would oppose.
Jay, and then Allan will be the last person.
Okay, first of all, on a savings clause, if Google is overturned, I'm all for it. Just to show that, yes, there are problems here with fair use and a savings clause that some would buy into and some would not. As far as international goes, there's a couple of issues on the international side and what they've done in other countries that could be instructive for us. Certainly the separation of non-commercial versus commercial uses has always been something that we think you should look at. But as a last point, I just want to jump on what Allan said a while ago about best practices, and while I am one who is very critical of them, I think if this is all going to work here, the idea of creating best practices in a way where all the stakeholders are in a room, possibly facilitated by the Copyright Office, to come up with the right questions and the right guidance. I think it's mentioned a couple times how hard it is for libraries to understand. I'm thinking in terms of if a library wants to find a very old esoteric sound recording that Jim's group, one of his members, might own, where would they even start? Unless Jim's group tells them this is how you find an old esoteric sound recording or an old musical composition or whatnot. So, again, this goes into the second panel, but I think that this all turns on us being able to come up with right guidance. Then maybe best practices could work.
Allan?
Well, I think that one of the problems here is that you can see the circular reasoning involved in these efforts to decide that you don't need legislation, you can rely on fair use, or perhaps a limitation on damages that authorizes a judge to consider orphan work status. What exactly would the judge be considering? Based on what? Is each judge going to decide what orphan work status means? Are we each going to decide what orphan work status means? Unless you have legislation, you don't have the ability to have consistent, uniform standards that are understood by everyone and that are applied in the same way. And if you don't have that, then you're not going to have the notion of equity, which is supposed to underlie both fair use and the treatment of orphan works.
This has been a presentation of the Library of Congress. Visit us at loc.gov.